Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We are continuing to evaluate the numerous responses to the various in limine motions that were filed on March 17th, 2025. The defense has sought to prevent the use of certain language at trial on the grounds that it invades the purview of the jury, that it would be prejudicial, that it should not be permitted to be used in front of that future jury. Well, the state of Idaho has come back. Said, Judge, you've got to deny this motion. The defendants asked this court to prohibit the lawyers or witnesses from using the word M, unaliving, or any form of the word. A recent decision from the Idaho Supreme Court, according to the state of Idaho, is instructive here. It is entitled State versus Radue, R-A-D-U-E, and here the state reports this decision in Radue, the defendant moved to prohibit the use of the term victim. Okay, it's not the same word, but they're going to make the analogy here. The district court denied the motion, preventing the state to use the word victim at trial. And the Idaho Supreme Court affirmed it. They said, District Court, you got that right. The Supreme Court of Idaho, according to the state, reasoned that the jury was instructed not to draw any inferences from the use of the term at trial. The court also pointed out, this is the Supreme Court of Idaho, that, quote, there was no dispute that the victim suffered from an injurious action of the defendant. Rather, the question was whether the defendant had the capacity to form the requisite intent to commit that action. Courts in other jurisdictions, so here we see the state looking outside of Idaho state courts for further support. According to the state of Idaho, courts in these other jurisdictions have used similar reasoning when allowing the prosecution to use the word M at an M trial. For example, in Virginia, the Supreme Court, they cite to. In Georgia, Louisiana, New Mexico. Here, the state then goes on at the bottom of page 2 to say, the use of the word M will not unfairly prejudice Mr. Kohberger. The indictment charges him with 4 counts of M, unaliving, in the first degree, citing to the indictment. That's what he's standing trial for, ladies and gentlemen, in addition to the burglary count. That's another first-degree felony. Moreover, according to the state, considering the evidence that will be presented at trial and the defense's theory, there is no dispute that 4 M unalivings occurred. The question for the jury will be whether the defendant, and this is italicized, committed the 4 unalivings. The defendant's position is that he was not present when they occurred, and he cites to notice of defendant's supplemental response to the state's alibi demand, stating defendant, quote, was out driving in the early morning hours of November 13th, 2022, as he often did to hike and run and or see the moon and the stars, end of quote. Defendant is not arguing self-defense or a lesser included form of homicide. On the other hand, the state will be prejudiced if it cannot use the word M, given the 4 first-degree charges. In closing arguments, for example, both parties are generally given wide latitude in making their argument to the jury and discussing the evidence and inferences to be made therein, citing to an Idaho Supreme Court case, State versus Godwin. So basically, the state is saying, turning the tables and saying, look, we're going to be prejudiced. If anyone's going to be prejudiced, if we can't use this word, look at what the indictment says. We will now await the defense's reply due the 24th of March regarding this in limine motion. Thank you for joining us here today.